Welcome everyone to Leigh Day's Regulatory and Disciplinary Team's event, The Quest for Regulatory Equality, specifically focusing on the disproportionate impact of regulation on Black, Asian, and minority ethnic lawyers, also known as BAME lawyers as well. We will now be introducing our phenomenal panel and our chair as well today. So the chair for today's discussion is Dave Neita. Dave is a lawyer, he is a published poet, he's a lecturer, a motivational speaker. He specializes in a range of areas, including mental health, law, diversity, creativity. He is a powerful advocate for human rights, campaigner for social justice, and has worked with some phenomenal organizations such as the Oxford University. We have NASA and Broadmoor Hospital, just to name a few. And he's actually delivered a sermon at St. Paul's Cathedral in London on redemption and transformation. So he will be chairing today's discussion. And the first panelist is Angela Latta. So Angela Latta is the LSB's head of regulatory performance and oversight. She leads on key interfaces with the regulators on regulatory performance policy, performance reviews, and remedies. She is also the sponsor for two of the longer-term LSB ongoing competence and diversity projects. So our next panelist is the phenomenal Sally Brett. Sally has made a career of championing and diversity in the workplace, following on from her previous roles with the British Medical Association, the TUC, and she has recently joined the Law Society as its head of diversity and inclusion. Okay, so our next panelist is Peter Herbert, who will be joining us very shortly. He is an OBE, also a former judge who has played a significant part on the ongoing quest for equality throughout the entire legal profession. He's recently retired from his successful career as an advocate and is now pursuing reparation and historical injustice projects in Kenya, and is the chair of the Society of Black Lawyers. Okay, so our next panelist is Emma Walker, who is an associate at Leigh Day in the regulatory and disciplinary team, which is also my team. She has particular expertise in the area of solicitors discipline. She advises individuals and firms subject to SRA investigations or prosecutions. She is committed to achieving access to justice for all, and is ranked as an associate to watch by Chambers and Partners 2021. And our final panelist is Gideon Habel. He is a partner at Leigh Day in the regulatory and disciplinary team. He specializes in defending and advising solicitors and firms responding to SRA investigations and SDT proceedings as well. He has a particular interest in exploring ways to make regulatory processes fairer, and is ranked as an up-and-coming individual in Chambers and Partners 2021. So without further ado, I will hand it over to the phenomenal chair, motivational speaker, poetry lawyer, Dave Neita. Take it away, Dave.
Thank you so much, Alika, for that wonderful welcome to us all and your lovely introductions of everybody. Alika, you are yourself, you're phenomenal. You're a phenomenal woman. Just read the Maya Angelou poem. Anyway, thank you everybody for tuning in. Thank you. We have over 100 people online watching, and this event is for you. It's about you. Solicitors, mostly, you're out there, and I know that every day you provide an essential service for vulnerable communities. You come from the Black community, the Asian communities, minority communities. You're providing a service every day to people, and sometimes you're roughed up and treated very badly by your regulator. And thus this event today. And I'm reminded by hearing some of the stories that I've been talking to so many solicitors who are doing this work, and I'm reminded, just listening to your stories, I'm reminded of the movie Roman J. Israel, starring Denzel Washington. If you haven't seen it, Panelists as well, everybody go see that film. And there's a moment in the film when the character that Denzel is playing, which is Roman J. Israel, and he works so hard and gives so much to so many people. And he just says in this one moment in the film, I'm sick and tired of creating the impossible, of making the impossible happen for the ungrateful. And sometimes I know the work is rough and it's stressful, but today is about you, it's for you, it's about you, it's for you to share, it's for us to connect, it's for us to listen to each other, because sometimes I know you're not heard, but it's for us to listen to each other and for us to come up with ways in which we can go forward in a very powerful and egalitarian way. So moving straight into the program, I want to introduce, to share her piece and her presentation on the report, the Guston report, phenomenal lawyer at Leigh Day, Emma Walker. Over to you, Emma.
Thanks so much, Dave. Wow, already a very tough, tough couple of acts to follow there. So I will do my very best. I'm going to start my section with a poll. And I want to ask a question to the audience, which is, do you think that the SRA is adequately tackling issues related to disproportionality and discrimination in the regulatory process? So there are three answers that you can give: yes, no, or don't know. And as you're casting your votes, I'm just going to explain that we'll be posing this same question later on in the event, to see whether the discussion that we've been having today has changed people's opinions. So please cast your votes. And whilst you're doing that, I just wanted to add that if you've got any real life examples that you've experienced or witnessed that you can safely share, then please do share them in the Q&A that Alika was mentioning, which only our moderators will see. And there will be an opportunity for discussion and questions later on in the event. So add any points there that you'd like to raise in the Q&A, and we'll come to those later on. I don't know if I've got have I got to submit a response as well, Al? Okay, so let's just have a quick look at the results. And I'm going to jot these down because, as I say, we're going to pose the same question later on, and let's see whether or not we have a change in opinion. So we've got 7% of people say that the SRA is adequately tackling issues related to disproportionality and discrimination. 51% of people say no, and 42% of people say don't know. So let's see how we do later on. Okay, so I'm going to share my screen with you now and talk to you a bit about John's review. So let me just bring that up and share my screen with you. And so the purpose of my section is to look back at what has been considered in the past to inform our present and future discussions. So looking back, regulatory disproportionality it's nothing new. The Law Society first reported on it in 2006, and since the SRA was established in 2007, it has commissioned 3 reports on the issue. The most recent is Professor Gus John's 2014 Independent Comparative Case Review, which is the starting point for this session. So what was the purpose of Professor John's review? In instructing Professor John, the SRA said it wanted an independent, comprehensive case file review to identify whether there is disparity in the way the SRA applies its policies and procedures in dealing with BME practitioners as compared to others, with a view to identifying potential improvements to such practices, policies and procedures to maximise fairness and consistency. But what do we mean by disproportionality in this context? Well, it refers to the proportion of solicitors from BAME backgrounds subject to regulatory action relative to the profession as a whole, and how the outcomes of BAME practitioners compare to those of their white counterparts. So what were the findings of the review? Well, the review noted there was evidence of disproportionality at 3 stages of the regulatory process: when a complaint was raised against a solicitor or firm, in the course of investigating that complaint, or when an outcome is determined and a sanction imposed. And looking at the statistics in the report that indicate regulatory disproportionality, we see that whilst practitioners from BAME backgrounds accounted for 13% of the profession, they were subject to 25% of new SRA investigations, 29% of interventions in practices, 32% of cases where conditions were imposed on practicing certificates, and 33% of referrals to the SDT. So what were the reasons the review identified? The review pinpointed a number of trends that could account for disproportionality. When compared with their white counterparts, respondents from BAME backgrounds going through the regulatory process had been on the roll for fewer years, they had been qualified for fewer years before becoming sole practitioners, and held fewer practicing certificates. Professor John provided a number of hypotheses for why these trends may exist, including that frustrations and limitations in career opportunities may result in BME individuals working for smaller firms or deciding to advance their prospects by starting sole practices relatively soon after qualifying. In other words, BAME practitioners were more likely to work in smaller firms. Smaller or less established firms and sole practitioners may lack the financial resources of larger firms that could act as a cushion against temporary cash flow problems, meaning they are more likely to find themselves under investigation resulting in sanction. As we'll hear in the course of this afternoon, the causal factors underpinning these hypotheses were hotly debated. They also had a significant impact on how the SRA has sought to address matters since the report. Professor John produced 50 recommendations for the SRA, the Solicitors Disciplinary Tribunal, the Legal Services Board, and the Law Society. And many of these recommendations tend towards 3 key themes: the importance of the regulator being transparent and accountable in the way it regulates, ensuring the action it takes is proportionate and targeted, and understanding the impact this has not just on solicitors and firms, but also the communities they serve and the wider public. So why now? So looking forward, why are we addressing this topic at this point in time? In its March 2020 5-year review of its equality, diversity and inclusion work, the SRA summarised some of the steps it had taken. Our anecdotal experience has been that the problem continues, and to date, the SRA hasn't produced any data to give an accurate sense of what, if any, progress has been made. So now, over 6 years since Professor John's report, we've reached a crucial stage. The SRA has said it will publish updated statistics on regulatory outcomes by early 2021. The COVID pandemic has highlighted disproportionality in our society. The Black Lives Matter movement has galvanised institutions and corporations into taking more meaningful action on discrimination, inequality and inequity. So this is a real opportunity to have an open and better informed discussion about regulatory outcomes. And so there is a real opportunity for accountability and change. So I'll be back later with a couple of polls. And so I'm going to pass back to Dave now. And thanks very much for listening.
Thank you very much, Emma. That's a brilliant outline, and I'm sure everybody will probably want a copy of that, which we're happy to make available, just so you can review it for yourselves. At this point in time now, we're going to have an anonymous solicitor give an account of the experience they've had in dealing with the SRA. So over to the anonymous solicitor.
Thank you. Okay, thank you very much. Being subject to an investigation is never easy for anyone. And when your regulator comes knocking, then you would have to have a heart of stone not to get a slight sinking feeling. I was told that they wanted to carry out an investigation. And although I naturally had this sinking feeling, I was able to tell myself it would all be fine, as I knew that I had not done anything wrong. I would be open with them and cooperate, as I had nothing to hide, and it would all be fine. Also, I'd spoken to others who had gone through the same process as me, and they too assured me it would all be fine. But then we have the luck of the draw, and I was not fine. I went through their disciplinary process and their complaints procedure, and at the end, I was left feeling a grave sense of injustice. Don't get me wrong, I've been a solicitor long enough to know that things don't always go your way, and you moan and complain, but by the next day you have moved on and yesterday is in the distance. But this was not things not going my way. This was a sense that something was done to me, and I felt depleted by the whole process and stripped bare. The whole process impacted on every aspect of my life, including my mental and physical health. In order to navigate the relationship with the person appointed to deal with my case, I had to turn to psychology. I felt that this person was holding back information. Not one question that I asked elicited a response. And any information that I provided was met with I have carefully noted, with no inkling of what in fact this person thought of the information that I had provided. If I always answered my phone, then this person would communicate with me via email. And if I never answered my phone, but always opened my emails, then this person would communicate with me via phone. Because quite simply, this person did not want to facilitate communication with me. On one occasion, this person called me and said, I tried to call you twice yesterday. I would check my phone and see that the calls were made from a withheld number, one immediately after the other within nanoseconds. And now that this person, and I would then know that this person was disappointed that I had answered the call that day. And not taking calls and opening emails is a thing, because the whole process leads to you feeling overwhelmed. In my case, I asked time and time again to be communicated with in a particular way, but this was ignored to my detriment, and my requests to them were never unreasonable. When you are trying to communicate with someone and they don't want to communicate with you, you are dependent on them because your relationship with the regulator is one of dependency, then it is a mind game, and mind games impact on mental health. I was invalidated, demeaned, and gradually my layers were peeled away. And I would explain something to them, which would be then ignored by them. I felt like I was a commodity and not a person who was entitled to human consideration. Think of a Crown Court judge handing out a whole life tariff to a defendant. I am sure that that defendant was afforded more dignity and more respect than was afforded to me by the regulator. And the relationship with the regulator is one of dependency. It is one which you cannot escape unless you choose to leave the profession. If you don't like your boss, you leave and get another job. If you don't like your partner, you leave. But why should you be forced to leave a profession you love because you don't like your regulator? But you know, for some of us, that is the reality. You are forced out because of the disciplinary process, or the fight has damaged your health, or you think, do I really want another 3 years of this? I asked myself, why me? And the only way for me to deal with it is to accept that for them, I was just a commodity. So on that level, at least it wasn't personal. And all through this process, I have told myself nothing matters apart from holding on to my sanity and to my dignity. And so the decision that went against me 2 days ago remains long forgotten. But the decision that went against me several months ago still rankles. It rankles because I know something was done to me. And that is my experience of dealing with the regulator. And I would just like to emphasize at this point that I have dealt with some decent people at the SRA. And I have dealt with some people at the SRA who have been totally professional. Thank you.
Thank you so much for that story, and really value you coming on here today and sharing your experience, an experience which is shared by so many other solicitors in your position all over the country. I can tell you that in the community, our solicitors from the Black and Asian and other minorities and what we call global majority really are respected and highly regarded and are appreciated for what they do. And yet, as you've just heard, the regulator make them feel disrespected, unvalued, make them feel inconsequential. And you heard the narrator now just telling you this term commoditized. And it's really awful. And I can tell you something, nobody that I have talked to, or nobody in this community of providing legal services expect not to be regulated. But as Maya Angelou said, it is in the way, Maya said it, she said it best, really. You might forget what people say about you or what the exact words they use, but you'll never forget how they made you feel. And so many solicitors from our communities up and down the country feel like they're disrespected, treated badly, inconsequential. And this term, commoditized, we're not a commodity. We're people providing essential service. And that's why this conference today is here to reinforce that you are valued. So thank you for joining and telling us your story. And I want to reinforce that you're truly, truly valued. And this is something the Law Society should take on board. And that's why I'm glad Sally Brett is here with us today. She's not been very long with the Law Society, but she's still joining us today. And I invite Sally now to give her presentation from the Law Society's perspective.
Thank you, Dave. And I apologise for my lack of detailed knowledge about the history of these issues within the solicitor's profession. As has been said, I've only been with the Law Society since mid-August, so I'm not familiar with everything that has happened since the Gus John report or the events that have led up to it either. But it's great to be here today and to learn from other speakers and to learn from the discussion. I wanted to talk a bit about my previous role, actually, which was as head of equality, inclusion and culture at the British Medical Association, which is the doctors' trade union and professional body. And during my time at the BMA, this issue of disproportionality in regulatory proceedings really came to the fore and was a major issue. And I recognise some of the similarities in what I've heard from Emma's presentation and from the solicitor who was just so eloquently and that going through regulatory proceedings has on individuals. So I'm going in recent years, beginning with the case of Dr. Hadiz struck off the medical register in 2018, and that was a case that really shook the medical profession. And the criticism it attracted, I think, shook the regulator, the GMC, who had pursued her erasure. So Dr. Bauer-Garber was a junior doctor who had been convicted of gross negligence manslaughter after the tragic death of a child that came about following a series of errors and equipment and system failures in 2011. And following her conviction, the Medical Practitioners Tribunal took the decision to suspend Dr. Bauer-Garber for 12 months. They thought that erasure would have been disproportionate. However, the GMC, the regulator, appealed that decision to the High Court and got her struck off, although that was subsequently overturned. And many doctors felt that Dr. Bauer-Garber was disproportionately blamed and held to account, including for wider system failings that were beyond her control. And the fact that Dr. Bauer-Garber was a Black female Muslim doctor, and that over 2 decades there had been lots of data and research from the GMC showing ongoing racial disparities in fitness to practice complaints, also created concerns about whether race had influenced the action taken against her. So under intense criticism, the GMC commissioned research from leading experts, Roger Klein and Dr. Doyen Atawalogan, to understand better the ongoing disproportionality in fitness to practice complaints in the medical profession and what was driving it. The GMC had done a series of audits and case reviews of its processes, and it had taken steps over the years to improve those processes, like specialist training for staff, appointing more diverse panel members, regular sharing of data about the processes and the impact by ethnicity. The key factor that came out of the report that Roger Klein and Doyen Atawalogan did, which was called Fair to Refer and was published in 2019, and I recommend people read it because it's a really excellent report that was very welcomed within the profession, and in fact I think changed the relationship somewhat between the profession and the regulator. And one of the key things they identified was the disproportionality, particularly in complaints coming from NHS employers rather than members of the public. And they described through their report, having done lots and lots of work with doctors and within trusts and with the BMA, that there were insider-outsider dynamics that were deeply entrenched in the hierarchical medical profession. And some doctors were more likely to be outsiders because of their race, ethnicity, or nationality, or because they worked in more isolated roles like being a locum or a sole practitioner. And similar to the solicitor's profession, BAME doctors were more likely to be sole practitioners. And they found that doctors who are outsiders face a series of risk factors in their careers that work in a cumulative way, including a lack of support and adequate induction at the beginning of their careers in the NHS, a lack of ongoing mentoring and support. It's much harder for them to develop those supportive relationships with seniors in the profession that help with feedback and learning and development throughout. And on the other side of that, the insiders, typically white, privately educated, usually with parents who were professionals too, they benefit from a series of protective factors that are the mirror image of the risk factors that outsiders face. This means they're less likely to get into difficulty and more likely to be insulated from blame when things do go wrong. And the report, the Fair to Refer report, recommended a lot more needed to be done to support BAME doctors throughout their careers, that when performance concerns were being looked into, there should be proper consideration of systemic issues and the context of the working environment that were likely to affect a professional's performance, and that the profession needed leadership that was actively inclusive, open, and continually listening and responding to concerns. These developments within healthcare, and it wasn't just within the medical profession, there had also been recent incidents within nursing of and in midwifery of BAME healthcare professionals being more likely to face disciplinary and regulatory action. And these developments in recent years in healthcare have really led to recognition at senior levels that we needed to move away from a fear and blame culture and towards a just and learning culture, with a just culture being defined as one where the primary focus is on establishing what went wrong rather than who did wrong, and what can be learned and what steps can be taken to prevent it happening again. So really it's about what was called forward-looking accountability rather than backward-looking accountability, about focusing on lessons and action for the system as a whole rather than focusing solely on remedial action and lessons for the individuals who'd been involved. So ensuring when things went wrong that the system understood and it targeted more resources and support to address and prevent the likelihood of errors happening in future. So coming into the legal profession and with that background and reading the findings and recommendations of the John report, and also having the opportunity in my first couple of months at the Law Society to listen to the experiences of Black, Asian and minority ethnic solicitors. The Law Society is conducting focus group research, and we've been running roundtables in response to the Black Lives Matter movements since the summer. And it's made me wonder if there are any parallels with the legal profession. Certainly in the discussions that I've sat in on, culture has come up a lot, especially talk about microaggressions and a feeling of not quite fitting in. It's evident that there are ongoing structural inequalities, with BAME solicitors less likely to stay and progress in big city firms, and more likely to set up on their own and to work in smaller practices. 35% of sole practitioners and 22% of partners in 2 to 4 partner firms are BAME, compared to just 6.5% of the partners in the biggest firms. So I know that the Law Society, following the John report, worked with our small firms division and our ethnic minorities lawyers division to roll out workshops on managing your own firm in different regions, and our small firms division is continuing to provide support on regulatory compliance and financial resilience issues, which I'm told do attract high proportions of BAME members. But we look forward to seeing the findings of the latest research that I understand the SRA is doing on the regulatory impacts, and seeing the new data come the new year. And off the back of our upcoming research, which will be launched on the 9th of December, and the engagement we've been doing across the profession, particularly looking at the underrepresentation of Black solicitors, I really hope that we can drive a focus on the need to improve race inclusion and race equality right across the whole profession to prevent the kind of disproportionate impacts that are clearly there at the moment. Thank you.
Yes, it definitely, Sally, thank you very much. Very useful. And based on what you're saying, I'm sure a lot of attenders here would be interested to get in touch with you to continue this work of capturing all these experiences and so on. So I'm sure you're available for that. I'm just going to share that when I, just coming to the next speaker now, I spoke to some solicitors about this issue that's affecting all of us, because it affects the whole community. And one solicitor I spoke with said to me, Dave, if you want to know something insightful about the SRA, go and check the SRA trusted pilot page. So I thought, let me do my research. Let me go and check this trusted pilot page. And I'm going to share with you what I discovered. You don't have to take my word for it. You can check it yourself. Here's what I discovered. On this page, you'll see excellent, right? You might expect a percentage. You know, we're doing a poll on this too. It's 0% response to excellent. Below excellent is great. All right, you might say, okay, something there. 0%. Below that is average. Average, okay, is less than 1%. Below that, what can be lower than average? Well, poor. Poor is less than 1%. But you might say to yourself, blessed are the poor, because there's even more under that. Below poor is bad. And bad is 99%. Now, this shocked me as a researcher, but probably wouldn't shock the community out there who is experiencing the harsher end of these procedures and regulatory behaviors. No, and I say this, if you discover this for any other profession that you're trying to engage with, not only would you not purchase those services, but hold on a second, you don't have a choice here, because as the anonymous person told us at the beginning, it's a monopoly. You have no choice if you want to be a solicitor but to be regulated by the SRA. But then you might think, I got to report this person. I got to report this organization. And who would you go to? Who regulates the regulator? And that's when we come to the LSB, the Legal Services Board. And here to talk to us today from the Legal Services Board is Angela Latta. So Angela, over to you.
Thank you very much, Dave. That was quite a powerful introduction, and I hope you've not raised expectations too high about the role. I think what I'd like to say is that we certainly recognise the disproportionality, and it's very much on the Legal Services Board agenda, and we are determined that we will be trying to do our best as in our oversight role to make sure that there is a better redress, there's a better system, there's better representation of all diverse communities across the legal services sector. What I'd like to do, if it's all right with you, is I'd just like to quickly explain what the Legal Services Board's role is, and then move on to talk about what we do with the regulators and what our focus and current emphasis is on diversity itself. And hopefully that will give you a better picture about what we do. So we're an independent body. We were set up by the Legal Services Act, which also created the SRA as a subset of the Law Society at the time. We're independent of both government and the profession. We're levy funded by the profession through practicing fees, as are the regulators. We share 8 regulatory objectives as set out in the Act with the regulators themselves, and there are 15 approved regulators altogether under the Act, and nine of those are actually regulatory bodies carrying out regulatory activities, of which the SRA is one and by far the largest regulator that we oversee. We do it in several ways. We've got some core functions. Our function is to make sure that the performance of the regulators meets the regulatory objectives in all that they do. We approve the practicing certificate fees. We approve changes to the rules, regulatory arrangements, and we also make sure that the independent regulation is carried out. And that's a bit technical, but it's really about the separation of the representative functions. So if we think about the Law Society, it's to make sure that the profession is sufficiently separate from its representative interests. And we also at the LSB take a more strategic role looking across the sector itself. So we've got 9 individual separate legal disciplines. So our job is to make sure that as a sector, as a legal sector as a whole, that we make sure that there's the sufficient evidence base, we understand where the issues and tensions are, we understand where there's trends, and we spot gaps where perhaps regulation is the answer. We also look after 3 other bodies, the Legal Services Consumer Panel, which present the interests of consumers. We also oversee the Legal Ombudsman, which is through the Office of Legal Complaints, and we scrutinise and approve their budget. We can call for reports and issue special performance targets for them, and we also approve the Solicitor's Disciplinary Tribunal budget. We don't have any oversight of the activities of it, but we do have scrutiny of the budget itself. So that's a kind of quick overview of what the legal service is about. In terms of the diversity focus, one of the regulatory objectives that I talked about before is about diversity, and our role as well as the regulators is to encourage independent, strong, diverse and effective legal profession. And we do that through a number of different ways. As an oversight regulator, our role is to make sure that we provide a framework for the regulators to follow all the regulators have quite a lot of flexibility afforded to them under the Legal Services Act on how they regulate the profession. It's their responsibility to regulate the profession, and it's our responsibility to make sure that the systems and the frameworks and the ways that they do that have in place are effective and that they are performing as at the highest possible standards. On diversity itself, we have set out guidance right at the beginning of the Legal Services Board in 2011. We published some guidance on what we wanted the sector to do in terms of collecting data and the kinds of issues that they should be addressing. We revisited that in 2016 and updated the guidance, and then through the year to 2020, we've published annual reports setting out what the regulators are doing on diversity. Now, a lot of that is down to what they are doing, and they determine themselves the action plans and programs that they have, knowing the sectors as they do. We don't profess to be experts on solicitors, barristers, legal executives, and all the other legal disciplines, because that's the role of the regulator. Our role is to make sure that the systems that they have in place are effective. This year, thinking about disproportionality, we set 3 further objectives for the regulators. Our guidance at the moment has 4 outcomes, and generally we work on an outcome-based framework where we provide advice and guidance about what we want the regulators to do, and it's for them to then determine the best way to make that fit within their sector. But this year, we introduced 3 new objectives that we wanted them to report against, and one was that to assure us that they had understanding the composition of their community. So what is the ethnic mix, what are all the protected characteristics, how well did they know it? We also asked them to understand the barriers to entry and progression. Since then, we're also looking at the retention of solicitors, and particularly those from ethnic minority backgrounds and those from the other protected characteristics. And then the third thing that we asked them to provide us with assurance on was that they had measures in place to understand the differential impact on protected characteristics within the disciplinary and enforcement procedures. And this was something quite new that I hadn't included in any of our policies in the past. So that was very much a new introduction. In terms of the ability of some of the regulators to meet that, or answer that question, if you like, only the SRA, the Bar Standards Board, and the SILEX regulation have sufficient numbers to be able to provide us with information and some kind of anonymized review of those characteristics. They are an ongoing part of our work and will be in the future. The 3 regulators did provide us with evidence. It wasn't what we would expect in terms of a sophisticated approach, but obviously the SRA, as we're talking about today, do have plans to provide some statistics, and I understand that's part of their report, although I haven't seen it. And so we are definitely focused on that. In terms of what the LSB is doing, I mean, we are looking at certainly improving our grip on diversity across the sector. You don't need me to tell you about how poor we are at in making any improvements. So there's plenty of activities happening across the sector through the regulators and the representative bodies. But in terms of the quantum impact, it's having such a small impact on the demographics as to be for us to call into question whether the regulators are doing the right things. So we are looking across a number of different activities this year. We will be reviewing our current policy guidance framework. We will be looking at how we hold the regulators to account through our performance framework itself. But we are looking at how we place a greater emphasis on evaluation, so that we know that what interventions and activities are working, where there are failures in the system, so that the regulators understand where they should be focusing their attention. As I said earlier, not just looking at progression within the sector, but also looking at retention. And we'll be testing, as I say, the effectiveness of our current policy. We'll also be working with the regulators and others. We have a very good relationship with the judiciary, and we take part in the Judicial Diversity Forum, and they've just recently published a statistical report on the demographics of the judiciary itself, which is fairly similar to the spread of the different demographics across the whole of the legal sector. We're also going to improve the intelligence and testing and refining our evidence base. We gather evidence and information, as I mentioned, across the sector, and we are looking at further segmentation of that to understand it a bit better. But also thinking about consumers, our greatest focus is on the impact on consumers from regulation, and we want to better understand not just the diversity of the sector itself, but the diversity of the consumers and how they are affected by legal services and how those are provided. So that's a quick whistle-stop tour as to the role of the Legal Services Board and our emphasis and focus on diversity.
Thank you very much, Angela. Thanks for laying out the role for us. And just to remind everybody that panelists will be here for quick Q&As. Please continue to type your questions in. I know that some of you came to this conference, you were drawn by all the panelists, but Salish, who is on the list, Salish Mehta, barrister, was not able to make it. He's in court at the moment and got a case, as he asked me to give his apologies, but he did say to me that some of what he would have shared, he wanted to share one particular point, and that is that he works in the BAME as well, and he represents pharmacists and surgeons and so on, and the very same trends we're seeing, the disproportionality within law is the same trend we're seeing in the BMA and with pharmacists as well. And Sally, I know you alluded to that as well. You have some experience in that. And we don't really need to do a poll to know what's going on in many homes in Black and Asian and the global majority homes. I mean, I come from one of them, and often you're told you can be anything you want to be as long as it's a lawyer, a doctor, or a pharmacist. So we are faced with a stark choice today. Either we're going to organize, because parents, moms in particular, try to encourage their children into a path that is good. But either we organize and try to tell these moms, you're sending your children in harm's way because of the treatment they're getting in these professions, or we're going to address this issue in the society and refuse actually to tolerate a sort of unequal playing field for people of different races and cultures. But Salish was not alone in fighting these issues. Peter Herbert from the Society of Black Lawyers has spent a lifetime fighting injustices in his profession and his vocational work, working with the Society of Black Lawyers internationally. In fact, today, guys, you didn't know this, but this is an international conference because Peter is coming to us live stream from Kenya, and Peter is continuing this great work there. Peter, I just want to welcome you. You actually need no introduction, but the brilliant and phenomenal Peter Herbert. Over to you, Peter.
Thank you, Dave, and thank you to the organizers, Leigh Day, Gideon, and others. Thank you very much, and for all the contributions made so far. I'd just like to sort of take this slightly wider and say that the SRA has to be seen in the context of wider political society and institutions in the United Kingdom. Several years ago, I got in trouble with the Judiciary Disciplinary Council because actually saying that part of the reason why racism still exists amongst the judiciary as anybody else is because we are not perceived as British. And, whilst there are the odd exceptions of poets and statespeople and athletes who don a Union Jack, as the author of the book once said many years ago, there ain't no black in the Union Jack. And historically, if you look at, and many people will sort of heave a sigh of relief and just, and pass over. But if you look at the history of the British Empire, slavery and colonialism, it is no surprise at all that the closer that a person of color gets to the centers of power, the higher the barriers will be raised to keep you out. And one of the ways in which control is maintained over people of color is discipline, regulations. And whether it is regulations on the plantation or regulation in the army, in the armed forces, or regulation amongst doctors. You are there, your presence is merely tolerated. And whether it's in Parliament or any else, we are far more likely to be disciplined than our white counterparts, whatever the profession. And if you go and talk to somebody in the Aboriginal community in Australia, or the Native American or Canadian community, they'll tell you exactly the same. The same disciplinary regulatory hurdles we face as Black professionals are exactly the same hurdles faced by people of color in France, Germany, Spain, Portugal, Canada, in fact, anywhere where people of color are historically in a second place. So as far as that is concerned, I think the SRA has to be understood that it is part of a wider historical legacy, whereas these institutions were not designed for our benefit. They were certainly not designed to have us as part of sitting at the table. And if you look at the example of Meghan Markle, without going into the details of that, the royal family was never designed to have a person of color in it, let alone to exist and have a parity. So if you look at what the SRA does, it was incredibly difficult for minority solicitors to even get a training contract in the 70s and 80s. And therefore, the disproportionality of our experience in terms of discipline should come as no surprise. You have grafted, therefore, onto this the nuances of racism, because racism has become more nuanced as the years have gone by. You will rarely hear a judge coming out with N in the woodpile. But behind it, you will have disproportionality, which says we're more likely to get a custodial sentence, less likely to be remanded in custody, less likely to have a non-custodial outcome by way of probation, and more likely, 6 or 7 times, I think it's actually 8 times more likely to be arrested on the way home, and our children. So when you come to those who would seek to defend our interests, who are they? They're actually solicitors. And one of the things that is a hallmark for a society, how do you protect your most vulnerable, whether they're people with mental illness or anything else? And your first port of call, the first defense line in terms of civil rights, is the lawyer. So therefore, if you are going to have lawyers of color who are, in a sense, treated with equality, you undermine the whole issue of the power base of UK society. So therefore, the SRA, whether it intends to or not, is simply another part of a historical legacy where racism and disparity are actually built in the DNA of the UK. Now, that is not to absolve those in power and authority. We're seeking to redress that imbalance. And so when you look at this issue, you see the fact that if you're going to, as a solicitor, appeal an intervention, you have 7 days. 7 days, that's all. Otherwise, your livelihood is gone. Who do you appeal to? You appeal invariably to a High Court judge who is the membership of whom there will be no African Caribbean person in the High Court judiciary at present, absolutely none. A couple of maybe deputies who squeeze through. There is no person of color in the Supreme Court still. And if you look at the Court of Appeal, nobody. You know, we're just about maybe get 1 or 2 Asians who've crept through. And we have to ask ourselves, you know, under what condition are they allowed through? Partly, obviously, through excellence, but partly because they won't rock the boat. And so a solicitor, a minority solicitor who appeals against an intervention, disproportionate intervention, which is our experience, will come up against a High Court judge. And I did some of these cases several years ago. And, you know, they wanted to see where was the evidence of racism. They couldn't find it. Well, of course, I mean, the SRA are not going to publish it and go waving a BLM flag about it, like a Trump supporter, but it's clearly there. And they weren't willing to look at the disproportionality that existed. And you have a fact that 97% of High Court judges emanate from the bar. So you don't even get the best of who there is, you get the best of what's left after solicitors have essentially been pushed aside. So each and every exercise of discretion depends upon generally a white person in power or authority, or a very, very tame minority person as well, and we exist as well, who have a stereotypical ability to undervalue our contribution to the legal frame society. What they tend to do is view us as second-class legal citizens in the same way as second-class citizens outside on the street. and you cannot divorce the two from each other. So in terms of criminal law, you will know from the David Lammy review that that was a serious indictment of the criminal justice system, but it can't be divorced from those who are, in a sense, fighting our cause within the courts. Generally speaking, either the commercial courts or the socio-economic courts, housing, immigration, welfare, etc. And what we find is that the attacks often are not just upon, as it is in actual very many autocratic societies of maybe the Philippines, Brazil, you don't only go after the indigenous people, you go after their lawyers. And should come as no surprise that people like myself, I think I've faced 11 disciplinary actions at the bar. 11. You know, one over which mirrors what the SRA have, where a judge in Cardiff Crown Court, the Recorder of Cardiff, asked me where I was born and threatened me with disciplinary action. And 2 cases involving the SRA. One was a young Asian solicitor called Shahal, who was told that he and his firm, and they were basically young Asian men who had set up in Coventry, we think the complaints about their firm came from local white solicitors in competition who feared losing business, and a disproportionate number of complaints about minority solicitors comes from the competition, or it comes from the police. It doesn't come from members of the public, it comes from sources which have a vested interest, either not paying a bill or making sure that the competition is diverted and sometimes closed down. So Mr. Chahal found himself prosecuted when he was told he wouldn't be. The SRA and their adjudicators, because in a sense they're all part of the same system, were asked to disclose why, in a sense, what lay behind this investigation. Rather than disclose these papers, the trial was stopped mid-flow. The SRA withdrew their allegations completely. But, you know, it ended up in causing him extreme distress and hardship. And the firm, and I think was, if not put out of business, it was certainly under the microscope for about 2 or 3 years. The other issue that it impacts upon minority lawyers, we're more likely to be in private practice, not because we like necessarily sitting and looking at ourselves in the office on our own, it's because of the racism we face getting into the mainstream profession. So it comes as no surprise that minority solicitors are more likely to be sole practitioners. But why? Do we like living alone? Do we like practicing? No, no more than anybody else. But we do so because we often have to face the overt or covert racism and applying within mainstream firms. And so if you look at the way in which, say, city firms operate, they're more likely to take a person from Brazil, Argentina, Israel, or Philippines and say they've got diversity than they are from persons who are indigenous people of color to the United Kingdom, because it makes their stats look good. And then when it comes to being regulated, you will have to look long and hard before you find a city firm who may have breached all sorts of regulations. And yet the reason they're not targeted, as Gus John and others have found out, is because they throw money at the SRA. Norton Rose, Herbert Smith, whoever they happen to be, can inundate the SRA with a team of lawyers from all over the world, and they have more income than the SRA makes in about 10 years in 1 month. So the SRA is very reluctant to take on city firms, not because they are not guilty of impropriety on occasions, simply because of fear. They simply couldn't cope. And so you have to look at really minorities, sole practitioners are disproportionately there because of racism, disproportionately investigated because of the same either institutional or stereotypical views, and we're less likely to receive the helping hand that a white practitioner might. Because if you look where, even to the composition of the SRA itself, it's a majority white organization. And I'm sorry, but if you look at the way in which race issues are dealt with from the primary school upwards, it is no surprise that if you go across to, those police officers that have the knee on the neck of a black suspect, that knee on the neck began in primary school. It began in secondary school and continued. It is not something that just happened overnight. So if you look at the way in which the regulator in Redditch, generally speaking, looks at their discretion. Do I push this minority solicitor down the road of assistance or discipline? They're more likely to end in discipline. And one of the things that Lord Ouseley found several years ago, there was flagging in the system. So solicitors of Sri Lankan, of Nigerian origin in particular, would be highlighted. Now, what on earth has the fact that a person is of Nigerian or Sri Lankan origin got to do whether they're culpable of anything? But it was there in the file. And so it comes as no surprise to me that institutionally the SRA really has a DNA in its racism, as do many institutions, and will deny it and write reports on it and explain it away by poverty, lack of training, you know, and all sorts of nonsense. And on the basis they are not there for their white counterparts. So summing up, really, Black Lives Matter. All of these UK institutions have really been given a kick. And it is the same type of kick that they got when they saw the uprising in Birmingham, in Handsworth, in Liverpool in 1981, again in 1985. You almost have to burn the place down to get a result, which is a reflection not on the Black community, African, Caribbean, Asian community, but on the institutions who have a vested interest in maintaining a status quo which protects white privilege. White privilege, whether it is in a city firm or a high street firm or within the judiciary. But there's a close link between all of these, which should not be forgotten. And whilst I'm in the closing remarks, because I know time is short, you know, the Law Society committees cannot be absolved from that, because the Law Society committees are disproportionately made up of people who have had in the past tense, membership of the SRA or benefited from that. So it's a very incestuous body, and this is the fallacy that it's supposedly at arm's length from government is a nonsense. There are times when you would be excused for thinking there is a phone call to be made, for instance, about Leigh Day and the Iraq cases. The SRA has a vested interest in seeking to highlight those who politically the government seeks to find a fault with. And it's no surprise that one is then investigated. So you can have political reasons for investigation, you can have competition reasons, you can have racism and gender discrimination, of course, and it comes down to maintaining that circle of power and influence. So, you know, past presidents of the Law Society can escape any disciplinary action almost, but, you know, those who are minority, and the higher they fly, the faster they fall. And I remember years ago representing Kamlesh Bal, who would have been the first Asian vice president of the Law Society. And you had a classic example of how the Law Society at that time, in a sense, had admitted almost a person of color to its higher echelons, but yet didn't really want somebody who was ready and able to make fundamental change. So the SRA is very much a link to a historic concentration of power and influence within the British legal profession. It's not unique, but I think certainly the Legal Services Board has to be an awful lot more dynamic than it has been in seeking to question what goes on. And, you know, David's question, who regulates the regulator, it's very difficult if the custodian, as the Romans would say, is just another centurion, you know, and the centurions, although people don't recognize it, were black and white. You know, when they marched along Hadrian's Wall. But the reality is, in Britain, generally speaking, the custodians of regulatory authority are the same custodians, in a sense, as they've always been. And we are always the communities that are perceived to be on the outside. So what the future holds, it should not take George Floyd's physically or metaphysically to endure that suffering before there is some redress. But my view is and those who want to, closing, if you look at the House of Lords report on racism, black people and the justice system, you will see a lot of similarities and a lot of lessons to be learned by the SRA. And the fact that there is some delay still in publishing those figures is testament to itself. And finally, I think, as for solutions, Derek Bell, who was a professor of history, I think, at Howard University once said that racism will only be overcome when the majority of white people see it no longer in their interest. When the majority of white people no longer see it in their interest. Sadly, most white institutions still see it as in their interest that racism and discrimination continue. And one of the things I think that needs to be advocated and advocated strongly is those solicitors who, and one is called in, who are presently anonymous, have to sue the SRA as a collective and a class action. There is nothing like legal action to concentrate the minds of those in power and authority as to what they are actually doing to a class of people. Class actions are not that easy in the United Kingdom, far more successfully in the US. But certainly one of the things I'm doing when I sue I'm suing the former Lord Chancellor, the Lord Chief Justice, and several High Court judges on the 8th of March in Leeds Employment Tribunal, is bring together my fellow judges, both present and past, and make the life of the British judiciary rather uncomfortable and bring home to them the cost of racism within their ranks. And that, sadly, is something that one has to do. I'm quite happy to be in Kenya, as you can gather. Thank you.
Peter, thank you very much. Very clear, very powerful, and very useful. We're moving swiftly on to Gideon. Don't worry, we're going to have time for questions. Gideon, please don't feel you need to rush this because your piece is critical. Gideon, partner at Leigh Day, will you give us your contribution?
Thank you very much, Dave, and thanks to everyone who has come along and all of our panelists as well. Now, in sharing in this event with you all today, as well as reflecting on some of the significant challenges that it seems to me remain with the SRA's engagement on the question of disproportionality, I also want to talk about some of the broader problems we've encountered with current regulatory system and how it's implemented, that I think could make a significant difference, not only to achieving fairness, but also to ensuring a perception of fairness by those going through the process and beyond. In thinking about this issue, I found myself wondering how best to set it up in a way that both reflects what we as a team have perceived as the SRA's approach to some of our clients' cases, but most importantly, how our clients have experienced the SRA. That perception and that experience has, more often than not, as we've already heard today, not been the supportive, measured and empathetic regulator that gives careful thought to the impact of their processes, but rather, from the early stages of investigations, appears to be a regulator intent on prosecution. It can very often feel to our clients as a question of us and them. As we've already heard today, there still seems to be a significant issue of trust as between the SRA and the regulated community. Some of these matters of trust have related to issues of race and discrimination. Others have reflected what, in my view, is a more general problem with the SRA's approach. But the lack of trust is also hinted at by the fact that so few people seem prepared to stand up and speak publicly about their experiences, seeking to hold the SRA to account in doing so, for fear of regulatory consequences. When the fear of publicly questioning a regulator's approach, in part for fear of regulatory consequences, has reached this point, there really is a cause for concern. But in looking at these issues, I don't want to do so without hope. And so I also look to propose solutions and ways forward that might improve things both in the short and the longer terms. So starting with them, in this case, the SRA, and some of the issues that remain around their engagement with disproportionality and enforcement. A major issue with the way the SRA has engaged on this issue so far since 2014 lies in what might be considered a limited transparency. There's no doubt that it has taken some steps to engage with the recommendations of Professor John's report. It's espoused a sustained goal of support for small firms as set out in its recent 5-year review, and it's taken steps towards that goal. The more open textured and flexible standards and regulations are also intended to allow for greater interpretation and modes of compliance to accommodate different approaches. A major issue remains, however. It's an issue that has perhaps added to the continued impression that despite talking a good game on the steps taken since 2014, the SRA has until now been unwilling to hold up a mirror to itself in the form of empirical data about the impact those changes on regulatory processes and outcomes. This is despite a huge push by the SRA since 2014 to improve its gathering and interpretation of EDI data about those it regulates more generally. It may be that there are good reasons why the SRA hasn't published this sort of data for over 6.5 years since Professor John's report, but it's not clear to me what those reasons are, not least that it did so in several years prior to the report. That failure to be transparent could be seen as an unwillingness to be so. The problem with that is that the data are among the clearest and most effective ways by which the SRA, the LSB, the legal community and wider society can properly assess what impact the changes are having. Without them, we're left in a situation where we're reliant on anecdotal evidence and individual stories rather than true regulatory accountability. Now that it's taken to undertake to provide these statistics once, it seems to me that the SRA must do so on an annual basis from here on. This will help to build trust among the profession that not only is the SRA committed to changing its approach and processes, but that it's also open to making itself as broadly accountable as possible. Another related issue where the SRA could improve its work dealing with the regulated community is in its relationship management. I say that this is a related issue because all of these are issues of trust and confidence. A regulator who wants to be accountable and make itself publicly so inspires important feelings of trust in those they regulate. In the fallout of the 2014 report, the SRA made clear its intention of the need to, its interpretation of the need to support those it regulates and to achieve a more nuanced and tailored understanding of their position. A key aspect of this in the early days was in the use of designated relationship managers or supervisors at the SRA. They ought to have been a particularly important part of building important relationships of trust and confidence with smaller firms in particular. But changes to the SRA approach in recent years have seen these withdrawn. It's introduced a confidential anonymous helpline since, for small firms at least, but it's not readily apparent to me how willing solicitors are likely to be to engage with and seek support from the SRA on an issue outside of the support of a personal one-to-one relationship of trust with a designated supervisor. That change is a change that, rather remedying the problem it's trying to solve, looks likely to be to the detriment of the firms the SRA set out to support in 2014. Finally, and again related to the question of relationship management, is the question of how the SRA's processes are experienced. And we've already heard this afternoon from one solicitor of her experience. She's not alone. Very often, our clients' overriding impression when they first speak to us is that the SRA's investigator has already made up their mind against them before they've even heard from them. This also comes with what is often experienced as a lack of empathy about personal circumstance or understanding, frankly, of what it's like to be a solicitor in practice, especially a busy practice where a solicitor is dealing on a day-to-day basis with highly demanding and emotionally draining client matters. I appreciate that in some cases the SRA may have good reasons to press if it has good grounds for thinking that in raising such concerns, the solicitor may be just deploying a delaying tactic. But where it's not, the approach can leave people feeling powerless, criminalized, and given the sense of a lack of empathy, scared. This is the more so when an impression of racial bias is formed, raised, and rejected without being upheld. Yes, the regulatory process is stressful, but the SRA knows that. And it's not, in my view, enough just to wheel out formulaic wording of acknowledgement when these concerns are flagged to them. Words are not enough. And in my view, it must do more to present a human approach in its work. I'm sometimes left wondering why it is that this apparently unsympathetic approach is so prevalent. Whatever the reason, it has the clear potential to lead to unfair outcomes, which aren't in the interests of the profession, the public, or indeed the SRA itself. In my view, the very fact that the possibility exists ought to be enough to bring about a careful analysis of its investigator's approach. And so what about us as members of the profession? What can we do to improve things, to make our contribution to achieving fairness and accountability? We all want a better relationship between the SRA and the regulated community. Losing good solicitors and firms because of regulatory action, where an alternative approach would achieve a constructive outcome, is a travesty and serves no one, least of all the public or the public interest. To play our part, we have to find ways to hold the SRA to account ourselves and ensure the system's working properly and fairly. We can do this collectively and we can do this individually. Collectively, we can take steps to achieve regulatory fairness and accountability by analysing the SRA's work and data, and importantly, in sharing our experience with the SRA through debates and events like this. Unfortunately, the SRA turned down 2 invitations to join the panel discussing this issue today, but we can still provide feedback to them through other means. Representative groups, direct feedback, the Law Society, legal press, and by responding to consultations. Individually, as solicitors in practice, the most practical way is by having a properly resourced plan ready in case it's ever needed. This will put us all in the best position to properly test and challenge an SRA case, rather than trying to manage its queries and inquiries whilst running around trying to do your day job as well, hoping that they will see sense and be done with things. Trying to handle an SRA investigation without help can take a huge toll on a firm's financial position as people and finances are diverted away from it. There's obviously insurance available for firms and firm managers to cover these costs, but it's no longer a mandatory part of PII. The SRA changed those rules to take it outside of PII in 2010. The absence of that cover from the minimum terms can put you at a disadvantage when it comes to responding to an investigation or prosecution, and that, in my view, makes it all the more important to make sure you're covered. Those of you who know this firm's history with the SRA will know how important it was to us in ensuring we are still here today. It made the difference. If we make sure we're all doing the best by ourselves with the right resourcing and support when the SRA comes knocking, we play our part in the regulatory system and ensuring accountability by robustly and fearlessly testing the SRA's enforcement work and making sure that the correct balance is struck, including in cases where the risk of disproportionality is highest. As I mentioned at the outset, in particular to those going through the SRA's processes, the relationship can feel very much like us and them. There are things the SRA certainly must do, in my view, that it can only do on its own to change that. But if we want the SRA to achieve its aims of reducing disproportionality, regulating fairly and transparently, we can only succeed in doing that if we all do our bit, and if them and us are prepared to come and to work together. Thank you.
Gideon, thank you very much. Very, very, very useful. I'm sure you'll be getting some questions. Stand tight, guys. We're gonna go into the Q&A shortly. But before we do that, Emma, I believe you have another poll.
I do, please, Dave. I just wanted to pick up on a point that Gideon raised in his talk by posing another question to the audience. And it's on a topic that, as Gideon demonstrated in his presentation, is something that is very important to us as a firm and something which is important to us as a team. And the question I'd like to ask is this. So for those who are regulated by the SRA, do you have the benefit of insurance to cover you for the costs of defending yourself against a regulatory issue? And as before, we've got the three options: yes, no, or don't know. So if you could vote now, I'd be grateful. I'm interested to know what your responses are. Hit those voting buttons, people. So the results are only 9% of people have got the benefit of insurance to cover them the costs of defending themselves in a regulatory issue. 40% don't, and 51% don't know. That is broadly consistent with other research that we've done on this topic before, and I would just encourage people to, if you don't know, go and have a look to see whether or not you do have cover, and if you don't have cover, have conversations with your broker or whoever it is that provides your insurance to see if you can get that cover, because as Gideon talked about, having a resource to be able to call on is hugely important. So thanks very much for responding to my poll, and I'll pass back to you now, Dave. Thank
you, Emma. And we might come back to why this insurance is really important, how we can insure ourselves against this business. We're going to go straight into the questions now. Before we go into the questions, I would be remiss if I didn't read a couple of the comments here. And the first comment, the solicitor, the anonymous solicitor who shared with us earlier, I hope you're listening. If you're not, I'm going to have to pass this on to you. I hope you're listening, because this one is for you. I totally agree with this solicitor. They're talking about you. What a courage to speak up, which I never had. Always kept quiet, cried in private. I want you all on the panel to absorb this. I want you to know what's going on with the mental health and emotional damage caused by this business here. I want us to really understand this and absorb it as we go into this Q&A. The next question I want to read is, the next comment I want to read is another anonymous attendee. I never had been a subject of any investigation from the SRA or the Law Society, but my horrible experiences was in the law firm I worked, right? But that's where in the law firm. Partner shouting at me, racial comments. I want you to be clear. I want you to understand the landscape, the legal landscape on which politically black people all over the world, Asian, global majority are facing right here in our legal profession, that we are, and we're not going to sweep it under the carpet, you know. We're not going to say we're going to address this thing. We're going to address this thing. I'm going to read one more, and then this neatly goes into a question, which I'm going to give to the panel. And this person, you know, is happy to be known, Lara Hosseini. I think that it's important to look at the history of the profession and the framework created for for working within those professions, i.e. doctors, nurses, lawyers, barristers. They were not created with BAME professionals in mind. This is alluding to what Peter was talking about, EDI, equity, diversity, and inclusion needs to be embedded in the work that regulators do. This is coming from Lara. Now, Lara follows up with a question, which I'm going to put to the first question over to the panel. Do you have any tips for how regulators could or should go about this? Gideon, take it on to start with. Peter, chip in on it. And maybe Angela, you should talk about this too, and Sally. Starting with you, Gideon, can you take on this question?
I'm just reminding myself of the question. It's a fairly long one, so I'm just having a look.
The idea of equality, diversity, inclusion, participation must be central to what regulators are doing. So yeah, certainly.
I mean, I am not an EDI expert, but certainly there's no question that is one core way, and I'm sure that Angela would be better placed to deal with this question than I am, of going about it. And certainly I'm aware that since at least 2017, the SRA has openly said that it is taking that approach in its corporate strategy. It has stopped dealing with EDI essentially as a separate issue in itself, and is trying to take an approach which essentially means that EDI is a sort of primary consideration in everything that it is doing. Now, obviously, I'm not here to speak for the SRA and how successful that's been, but that is one approach that I know is being adopted. And as I say, I think it might be really for Angela as our LSB panelist to be able to speak more expertly to that than I'm able to.
All right, Gideon, thanks for that. I have a direct question for Angela. So Angela, I'm going to keep you on hold for now. Sally, I'm going to ask you to think about responding to that question. But that same question, I want Peter and Sally to address this question. First you, Peter, then Sally. The question is clear to you guys? Just read out. Peter, go ahead, if you're on mute.
Okay, you want me to go first?
Yes, go first, Peter, and then
okay. I mean, very simply, EDI, I mean, the euphemisms people use for anti-racism are very straightforward in the sense of what you need is every single exercise of discretion should involve what I would call the reverse Rooney rule. How did was that discretion exercised fairly and tested against the commonality of what happens to white solicitors? Because if you don't look at equality of impact at every particular exercise of discretion and have somebody else audit it, it remains a subjective judgment by generally white males within the SRA. And so you have to look at the complaint. Was it a fair, legitimate complaint in the first place? Once you've decided a particular route, every exercise of discretion must be subject to independent scrutiny review. Only in that will you obtain some redress. And I'll give you just one example. We used to have in the Crown Prosecution Service promotion that could only be accessed by having a positive subjective report from your immediate superior. What we did back in the early 2000s, we looked at that and we looked at the prosecution decisions of the exercise of discretion. I think Gus John's report would back me up. And what happened was you had an independent, even within the service, review where someone double-checked that. And so from my own view, you have to drill down to the individual case, because the individual cases are where the discretion is exercised and goes wrong. And if you see that, for instance, there's a disproportionate response to minority solicitors in sole practitioner firms, you may think, well, hold on a minute. Do we do this for city firms for the same infraction? If not, then you have to level up to provide exactly the same response. to sole practitioners, BME practitioners, as you do to city firms. And that's, if you don't do that and regulate it every case, every month, every year, every region, you will inbuilt that institutional racism which perpetuates disproportionality.
Thank you, Peter. And I want to come back to you on a related question. Sally, do you want to respond to the question?
Yeah, sort of building a bit on that, from what my experience of working on these issues in the medical profession it's where we got to within medicine, and post Bauer Garber, one of the things that was being considered there was also not the disproportionality comes not just from the treatment of BAME solicitors being over-referred and over-investigated, but perhaps an under-investigation of the insiders when things go wrong as well, that difference in treatment. Having said that, so it's really important to have accountability as well. So I know like one of the most common responses, which is important, is to make sure that everyone involved in decision making is aware of bias, their own individual biases and unconscious bias. That's the kind of knee-jerk immediate response. But it's also very, very important to have accountability of the decision makers, for them to know that their decisions are going to be monitored by ethnicity, to look at the all of the systems and whether there's any inbuilt bias and what can be done within those systems and processes to remove the impact of bias. So, it's not just down to the individuals to control it themselves. You're also looking at how decisions are made and making sure that there's enough checks on every individual in that system. But the other thing is what we learned within medicine and healthcare is to try and stop people getting into these kinds of procedures in the first place, because once people are in formal disciplinary procedures, they have a terrible impact on individuals. We've heard that even when they're exonerated, eventually they're really emotionally draining. And so you need to really make sure that they are that everything is being done to support individuals so that they don't end up, so we're identifying early on where people may be struggling or getting into difficulty and where more support is needed. And also before any decision is made to refer people to a regulator or into formal disciplinary proceedings, in the NHS we developed, there was an incident decision tree to really check whether or not there was, it was likely that an individual had made a deliberate or very reckless decision or behaved in that way. If it was a genuine error or mistake, then that should be dealt with in a different way, not formal discipline and regulation.
Thank you, Sally. Quick one for you, Angela. This was directed at you. It comes from Katrina Robinson, MBE. My question is whether or not the LSB should provide compulsory sentencing guidelines to be used by the regulators when certain acts have been found to have occurred, regardless of subsequent apologies and matters in mitigation. It's a question about uniformity across the board. Over to you, Angela.
So that's a very good question, and it's not something that we have become involved with. We have regulators who have regulatory boards, and the regulatory boards are designed to provide the governance and structures in place to determine what's required into each of the regulatory disciplines. So we would not seek to be able to try and determine a set of guidelines that would apply universally, and our preference is to allow each of the individual regulators to determine the right level of remedies that are required. Some remedies are set in law, so the solicitors regulation authority have remedies that they're constrained by, and the SDT have different remedies, and the barrister regulators and disciplinary bodies have as well. We wouldn't seek to try and determine a kind of menu of options on remedies, because that then takes away the flexibility to be able to determine on the merits of the case what remedy should be applied.
Thank you, Angela. It is mandatory for drivers to get car insurance. Now, Gideon, you mentioned insurance, and you know, in the world of smash up between solicitors just trying to get about their business and the SRA, just give us a little bit more detail about why you think. I mean, I'm sure you're not saying it's mandatory, but why are you driving home this point about getting insurance? What's the importance of it? It sounds like you're saying it's likely that people are going to end up in a smash up situation. And if they do, what you're going to do? So Gideon, and maybe Emma, if you want to chip in.
Hi, thank you very much, Dave. So I think overall it's probably not necessarily a typical experience for a solicitor to go through an investigation with the SRA. Almost all solicitors, I think, will have some contact with the SRA at some point. But the importance of insurance is exactly what it says on the tin. It's making sure that if it does happen to you, you are able to access at a reasonably affordable cost, rather than having to pay for the services out of your own pocket once the horse is already bolted, if you're inclined to do that. But essentially accessing a resource in an affordable way that will enable you to essentially, to a large degree, offload the burden of engaging with the SRA, enable you to put together the right tone of response, the right structure and evidence gathering exercises that need to be gone through, and manage that relationship with the SRA in a way that best puts your best foot forward and gives you the best possible possibility of demonstrating to the SRA the truth of the position. Because all too often, it can be the case that solicitors, in trying to do their very best in managing their own practices and in managing their relationship with the SRA, find themselves in a situation where resources, both in terms of time, which is an incredibly valuable resource to most solicitors, both in terms of actual financial value that you can be spending on other case running work, fee earning work, or otherwise business development, whatever, has to be spent and diverted away to essentially what is a resource pit, a well, essentially, where you are not getting it back. And if you can actually outsource that to people who can do the work for you and to explain and manage that relationship with the SRA, it's a massive benefit. But because of the fact that that sort of insurance is no longer part of the PII cover, which is mandatory for firms, many firms, as we've just seen, only 10% of those who actually responded to the question knew that they had that sort of cover, and 50% of people didn't know. That's, I mean, not unusual, but it's really important if you do end up in that situation, that you have that sort of resource to be able to bring to bear in your defense. It's vital, as I say in that little presentation, to be able to do that, to make sure that the SRA is being tested and challenged when it's following up on complaints and carrying out investigations.
Brilliant. Thank you. Thanks for that, Gideon. That's very clear. Emma, did you want to add anything to that?
Just very quickly, because I think Gideon has answered the question, but it's really just to say that it's something that came up in our own case. I think we've been vocal about the fact that it did, and that it struck us that there must be other solicitors out there who either don't know whether they've got cover or assuming that they do have cover, and it's only when they are faced with a situation where they have to respond to the regulator that they discover that actually that they don't. And it's about what Gideon was saying, giving yourself the resource, and that's what it is about, really. It's that, and bringing about equality of arms with the regulator. So just check to see whether you've got it, and if you don't, see if you can do something about it.
Thank you, Emma. I think that's very wise, very prudent advice. I'm going to go to another question here. This question comes from Kiran Dwarka. I think I recognize the name, big employment solicitor, significant in the industry. This question, Peter, I hope you're there, because this question follows on from something you were saying. The question is, should there be a lower regulatory bar for small firms and sole practitioners? I mean, this cuts across a bit what Peter was saying about look at what's happening in a high street firm and then graduate that up. But this is, Peter, take on this question for me, and then maybe somebody else can chip in as well, maybe either Sally or Angela, but Sally, you should. Should there be a lower regulatory bar for the smaller firms and sole practitioners? If you unmute, Peter. Unmute.
Yeah, beg your pardon. Yeah, I think it wouldn't be about a lower bar, but it's a different bar. I think often, because in a sense there's a hidden one, as I mentioned earlier, by city firms. The SRA has a mountain to climb on taking on a city firm because it will be out-lawyered effectively. And so it's very reluctant to go after city firms by comparison. So what it is already built, there's already a built-in unfairness to target easy targets, low-hanging fruit, which are perceived to be sole practitioners. So what I think should be said is, unless it's an affair of outright dishonesty, then you have to force the SRA to go through the stage of constructive engagement. Only if constructive engagement fails, then you then proceed to some disciplinary action. And now that is not a necessary step for city firms, simply because they've got the resources, and they should, given their resources and experience, they should not be in the place of breaching any regulations, because they are strong enough, well-resourced enough to have one team, say in the litigation team or the commercial team, to regulate each other. And so I think that a sole practitioner, the SRA ought to be forced through the line of constructive engagement before it even gets to a disciplinary action. And sole practitioners are, say for instance, you don't want to pay a bill. You make a complaint against the sole practitioner and the bill isn't paid. Now, generally speaking, a city firm, low betide you if you dare not to pay their bill. And just to give you an example of an even larger minority firms, there was a minority firm who was run by an Iranian lawyer who has since been struck off. The SRA spent millions of pounds chasing him to California, uphill and down Dale, to collect evidence against him. A lot of it was in breach of US Californian law. And, he luckily had the resources to challenge it. But, we still don't know how many millions of pounds the SRA spent, because it never thought it would be called into account. And it, as I say, one of the systems that I didn't mention earlier, the SRA will actually, when it comes to regulation, will often be able to line up a sympathetic high court judge. And therefore there is a weighted decision weighted against the sole practitioner. So it's very important, as Angela and others have said, not to let the minority solicitor sole practitioner to get into the disciplinary meat grinder of the SRA in the first place, because that's exactly what it is.
Peter, brilliant. I just got the signal. It's not on you, it's on me. I just got the signal that I went over, and it's a weakness I have. My apologies to everybody. But guess what? I want to capture every single comment and question in this sphere box that hasn't been addressed, because we are having a follow-up another seminar, conference, and so on. You've been absolutely brilliant. You've been amazing. We're not done. Just give me one more chance to put in 2 more elements here. First of all, thank you so much, panelists. You've been amazing. You're gonna get that. But before we round it up, and thank you so much. Before we round it up, Emma, I think you have another poll.
If I may, Dave, I'd love to ask the question that I asked at the outset to see, as I said at the beginning, whether or not the discussion that we've had today has changed people's opinions. So I'm going to ask the same question I asked at the beginning, which is, do you think that the SRA is adequately tackling issues related to disproportionality and discrimination in the regulatory process? So I hope you've had fair warning of this question. So please hit your vote buttons now. Yes, yes, no, or don't know, and let's see how we did in comparison to the poll that we had at the beginning. And I've got the results from the earlier poll, so we can compare those.
Yes.
Go for it, Alex.
We're on the edge of our seats. We're on the
yeah, let us know the results. Oh my goodness. Okay, so we've got 1% of people think the SRA is doing enough, 90% say no, and 8 say don't know, and that's in comparison to 7, 51, and 42% that we had at the beginning. So yeah, so thanks very much for voting in my polls and sticking with me. And it looks like the discussion has changed some opinions, so that's great.
Absolutely, Emma. That poll is damning. Based on the information that we had today from a very balanced and diverse panel, we now know that 90% of the people here, I mean, it's just 1% who think yes. I think that represents a person. And I tell you what, this has been a phenomenal experience. We have learned a lot. I hope you feel loved. I hope you feel valued in this session, because that was the whole purpose. I know the work out there is the graft is tough and you're treated badly, but this forum is to create some self-love for solicitors and for us to reach out and see if we can change the landscape. I am indebted to every single panelist. I know some of them, and I'm so grateful to know them. The ones I've just met, great to meet you. Let's keep in touch. And I have to say, I do know the person closing us out, and it's Alika Lee-Crandon. Absolutely phenomenal. Her opening and now her closing. Alika, thank you so much. Will you take us out? Thank you. Thank you all.
Firstly, I just want to say, have to 100% echo what Dave was saying. This was a phenomenal discussion. I was definitely screaming in agreement whilst I was off camera at so many of the points. So thank you so much to absolutely each and every one of the panelists who have dedicated their time to come and speak at this event. Thank you for everyone who has taken the time to sit down and listen. We are so grateful and very excited to see you guys at the next event in early 2021. So keep your eyes peeled. But definitely in the meantime, we have resources for everyone here. So now that you guys have been to the webinar, there are also resources that you will have access to, which include conversations between Dave Neita, phenomenal chair, which you've seen today, and also between Gus John as well. We have members from the panel who have dedicated their time to create resources, etc. So feel free to read and look into the same issue between now and our next event. So yes, for now we will say goodbye, and thoroughly excited to see you all at the next event. Thank you so much for attending, everyone.
Thank you.